Do not use supplements in law school. Don't do it. Don't you do it. Don't do it. Right? So I recently got this email from a new 1L in their first week of law school, and their professor told them that if you use supplements this early in the process, you will never develop the necessary analytical skills to be successful in law school. Yikes. And this is not a one-off interaction. My 1L students tell me all the time that professors put warnings like this in their syllabi, in their first day of class lectures, and that even student services and the dean will talk about this in orientation. So what is the deal? What exactly are supplements? Why are law schools so scared of them? And should we actually be using them? So first things first, what is a supplement? Well, a supplement is kind of just an all-inclusive word for any out-of-class resource that is designed to explain the rules of law in a clear, structured, easy-to-understand way. And supplements were traditionally referred to as hornbooks because they took the form of these sort of short, mini textbook kind of Cliff Notes versions of the rules of law for the 1L doctrinal subjects. So civil procedure, contracts, torts, criminal law, property, and constitutional law. And now there are a lot of different brands that make supplements, and they come in both written form and video form. But again, the purpose of these supplements is to explain the rules of law in a clear, structured, easy to understand way. Awful, right? But hang on, isn't that a good thing? Isn't it a good thing that we would have resources that tell us what the rules of law are so that we can learn the rules of law, so that we can then pass the bar exam and go on to be a practicing attorney who uses the rules of law? Well, therein lies the conflict, because most law schools, and by extension, law school professors, do not see it as their job to teach us the law. Ostensibly, that is our job that we as law students do on our own time. Law school professors see their job as teaching us how to think. And because of that, in law school, supplement is a dirty word because it just gives us the rules of law without us having to think about how the rules of law came to be, how the rules of law fit together, and God forbid, how we would actually use the rules of law on a final exam essay answer. And because of that, professors try to shame and scare us into not using supplements because they don't give us the proper analytical skills necessary for law school success. Now, to understand this claim that professors help us learn how to think, or learn how to think like a lawyer, or develop the proper analytical skills necessary for law school success, we need to understand the case-based teaching method. So starting back in the 1880s, law schools started using cases, i.e. written judicial opinions, as a way to teach law students the rules of law. And the idea was, rather than just give us the rules of law and lay them out like a supplement would, right, in a clear, structured, easy to understand way, we would instead read the actual judicial opinions that created these rules of law or used these rules of law so that we could have more context for how these rules of law got created in the first place, or what the facts were that the courts used to find that a rule of law was met or not met. Now, there are 3 reasons why using a case to try and teach someone a rule of law is a terrible way to go about it. And the first one is that cases are not written with law students in mind, meaning when judges sit down to write these opinions, they're not writing them for law students as their audience. And so as a result, they are not identifying these rules of law in a clear, structured, easy to understand way. And so when you're talking about someone who is learning an area of the law for the first time with no context and no expertise, it makes it insanely difficult to try to identify what these rules of law actually are. Not to mention, the words rules of law is actually quite ambiguous. It can be a bit of anything. It can be a new legal definition for a term. It can be an element that is added or taken away from an existing rule of law. It can be a factor test that a judge is using to determine if a rule of law is met, or any other number of formulations. And so at the end of the day, trying to go through these long, convoluted legalese opinions in a desperate attempt to extract what you hope the rule of law is incredibly inefficient and time-consuming. The second reason is that even if we do come across a case that does identify a rule of law in a clear, methodical, easy to understand way, that is still only one data point. That's only one rule of law, and it doesn't give us context for all of the other rules of law that make up this legal framework as a whole. And we need to know the entire legal framework, including where the rule from this case fits in order to actually be able to answer a question on a final exam. And the third reason is that in law school, we are under an insane time crunch. The quantity of legal rules that we are expected to know by the end of the semester is massive. And so even if we wanted to give in to the case-based teaching method that our professors are telling us is so great and doing everything that they want us to do, what winds up happening to 99% of 1Ls is that we spend all of our time reading and rereading these cases, trying to identify this rule language and every other aspect of the case we're supposed to know, which leaves no time on the back end to actually review these rules of law and practice them for the thing we're actually evaluated on, actually graded on, which is the final exam at the end of the semester. The other stated benefit of reading cases in law school is that it helps us to think like a lawyer. Now, I will concede that reading a case is a way to show ourselves how another lawyer, i.e. a judge, is presented with a factual situation and then has to reason his or her way through whether those facts satisfy the language of a rule of law or don't satisfy the language of a rule of law. But what I will say is that that is not us analyzing anything. That is us reading how another person analyzed something, which is not zero value, but it's certainly not the most valuable thing that we could be doing with our very limited time in law school to develop the proper analytical skills needed for law school success. The way that you do that is learning the rules of law and then you applying them to a fact pattern. In other words, practice exams, actually practicing the thing we're going to be evaluated on and graded on at the end of the semester. And so if we're spending all of our time trying to memorize and regurgitate what a judge reasoned in a case for classroom discussion, we are not leaving ourselves critical, valuable time to do the actual exercise that we are going to have our grade based on. So if what we actually want is law students to be able to develop the proper analytical skills necessary for law school success, we need to give them what they need to do well on the thing we're grading them on, which is final exams. And so that would include step 1, teach them the rules of law in a clear, straightforward, methodical, structured way before we do anything else. Step 2, then and only then would we introduce cases to show them how these rules of law have been used in previous lawsuits to come to an outcome that certain facts do satisfy the rules of law or certain facts do not satisfy the rules of law. And then step 3, we open up a ton of time for law students to then practice that skill themselves. Take the rule of law they just learned, take a hypothetical fact pattern, and go through the analytical steps of reasoning whether the facts satisfy the rules of law or the facts do not satisfy the rule of law. The way we do it now is completely out of order. Trying to use cases to teach law students the law is a terribly inefficient way to do it, and then requiring them to just regurgitate details of how a judge has already gone through that analytical process, leaving no time for them to actually review, learn, internalize, and practice with the rules of law on their own. All right, guys, that got a little intense, but I feel so strongly about law school professors giving you guys bad advice, outdated advice, gaslighting you into thinking that the way it's always been done is the best way to learn this information and learn these skills, which is simply not true. And so if you have any comments, any questions, feel free to drop them below. I'm happy to hear other perspectives. And if you are curious about my favorite way to go about law school strategy, definitely check out my free Beat the Curve guide here. I'll link it above. And with that, guys, I'll see you in the next video.